up to page 17, we covered that issue of jurisdiction, particularly of IEBC, the commission being the one also hearing the dispute, and all that is well covered there. Now, we would wish to straight away go to our findings on these matters. Findings. It's apparent from the submissions of all parties that at the core of the consolidated complaint is the issue of whether the first respondent is a registered voter. If indeed the first respondent registered as a voter, then it was incumbent upon her by dint of Section 6 of the Elections Act to verify her registration status with the Commission. If she indeed registered as a voter and elected not to verify registration, then she has no claim against the Commission over non-registration. Section 2 of the Election Act is clear that a voter is someone whose name is entered in the register of voters. The committee heard from the second respondent witness, Ms. Kasait, that the first respondent registration details do not appear in the biometric register and the non-biometric register. The committee has, upon request of both the complainants and respondents, ordered for production and inspection of the Green Book in respect of NCC Social Hall, where the first respondent claims to have been registered. Her name does not exist in the said register. We note that the second respondent's witnesses, Kasaita and Ms. Mwai, testify that the Green Book is the original data entry source for purposes of voter registration. The Supreme Court, in its above-mentioned decision, also found that the Green Book was part of the register of voters. We also note that the first respondent, in cross-examination of the second respondent witnesses, claimed that the ballot box containing the Green Book register produced before the committee had been tampered by agents of National Security Intelligence Service, NSIS. However, the first respondent has not filed an affidavit or put its witness on the stand to provide the particulars of this allegation or let evidence to prove its claim. It remains a bare allegation made from the bar. Based on the evidence and submissions before the committee, we find that the first respondent is not a registered voter as evidenced as emphasized by Section 2 of the Elections Act. With regard to the acknowledgement slip produced by the first respondent, it is the committee's view that the said document does not have a legal weight or status and is therefore not proof of registration. In addition, even if a legal significance of registration were to be attached to the document from the testimonies of both the first respondent and the second respondent witness is incompatible with the facts of the alleged registration date and the registration centers in which the second respondent claims to have been registered. It's worthy to note that the first respondent did not seem to know the physical location of the registration center where she went to register as a voter. Even if it was indeed assumed that the second respondent indeed presented herself for voter registration, it is clear that by dint of registration section 3A and 3B of the elections regulation, registration of voters regulation, the first respondent would not have been validly registered as a voter since by our own admission, she did not have our original identification card or passport as required to register as a voter. We find in light of the foregoing that the issue as to whether the first respondent was done in compliance with Section 13 of the Elections Act is now moot and does not fall for determination. Orders. First, the first respondent having not been validly nominated, her nomination certificate issued to her by the returning officer Makueni County on the 27th of June 2013 is hereby revoked. The third respondent do take immediate steps to commence investigation to determine how the acknowledgement slip issued to the first respondent herein was issued. Orders accordingly.